The constitutional guarantee of the right to equality has always enjoyed a privileged status in the constitutional jurisprudence of India. Under Article 14, we all have the right to equality as guaranteed by the Constitution of India. Hello everyone, my name is Samanvi, and in today's video we shall be discussing the doctrinal development, the doctrinal tools that have been developed under Article 14 in light of the recent judgment called Rajbala versus State of Haryana 2016 judgment, which has changed the dynamics or changed the standards of the test under Article 14, test of negation under Article 14, that is right to equality. Uh, in the case of Rajbala versus State of Haryana, the challenge was of the constitutional validity of the Haryana Panchayati Raj Amendment Act of 2015. The provisions provided for various levels of minimum educational competencies for contesting elections to the different posts in the village panchayat. These were contended to be wholly unreasonable and arbitrary. Now, when the question of arbitrariness came before the court had highlighted that it cannot intervene intervene to examine the legislative wisdom with which the legislation has been made. It did not intend to provide a value judgment of the legislation to simply say that because the legislation is arbitrary, hence the piece of legislation is unconstitutional. Now, thereby deviating from all the previous judgments that the Supreme Court has given in line of the doctrine of arbitrariness and in line of the Article 14, the standard of violation under Article 14. Now, before proceeding with what are the tenets of criticism under of this case, let's try to understand how have the doctrines evolved under Article 14. Now, we all know Article 14 is divided into two parts. It has two concepts. One is equal protection of law, the other is equality before law. The equality before law has been imported from the A.V. Dicey's rule of law. The equal protection of law doctrine has been imported from the US Constitution. Now, the doctrine of equal protection of laws prohibits class legislation, but it permits reasonable classification of persons and things. Now, since the words were directly imported from the 14th Amendment to the US Constitution, the Constitution makers have intended and clarified to show that they want to approve the interpretation of the clauses also, which were given by the US Supreme Court. With this, Supreme Court has applied the theory of reasonable classification evolved by the American Supreme Court to give content and true meaning to the right to equality as given under Article 14. Now, whenever a classification is made between between two persons, we are trying to say that we are grouping one person on the basis of one ground in one box and the second on the other ground in the second box. Now, this classification, these grounds are always in question when we talk about the reasonable classification test. Now, this is where the very first judgment of Anwar Ali Sarkar versus State of West Bengal derived or enunciated the classic nexus test, which talked about the two conditions that had to be fulfilled. The first was intelligible differentia. It should be proven that the classification is founded on an intelligible differentia. The second is that the differentia must have a rational relation to the objects sought to be achieved by the act. Now, between these two tests, you have to prove that there is a nexus, that there is a connect. Now, if you've proven that there is a connect, there is a nexus, hence you can say that the classification is a reasonable one. Otherwise, it would be held as unconstitutional. Now, the reasonable classification test has evolved as a doctrinal tool almost 6.5 decades ago, that was evolved 6.5 years ago, continues to hold its relevance and appeal in the contemporary constitutional discourse. Now, this is quite evident from the fact that it continues to be a dominant test in deciding upon the violation of the right to equality enshrined under Article 14. Nevertheless, Given the relative unease with the doctrine's undue emphasis on the distributive aspect premised on the discrimination vis-à-vis a similarly situated and distinct class of persons, it was soon discarded by the Supreme Court. Now, for a long time, reasonable classification test has been upheld. The classification test that was brought in the case of Anwar Ali Sarkar has been upheld in several other judgments until the case of E.P. Royappa versus State of Tamil Nadu, in which the question came of intersection between administrative law and constitutional law. Now, since the administrative law had come into picture, the way of executing the powers, the way of executing a legislation had also come under the question before the court. Now, this is where Justice P.N. Bhagwati had introduced the test of non-arbitrariness. Now, we have to be mindful of the fact that E.P. Royappa does not overrule Anwar Ali Sarkar to clearly say that we do not have reasonable classification test now. We would have the test of non-arbitrariness now. What we intend to mean by the judgment of E.P. Royappa is that not the test of arbitrariness, that whether whether a legislation is arbitrary or not, whether the manner in which the power has been exercised is arbitrary or not, is over and above the reasonable classification test, and therefore arbitrariness, to evaluate the arbitrariness of the legislation, is another facet of Article 14. Now let's see what Ajay Hasya versus Khalid Majib had to say about this test of arbitrariness that was given in the year of 1973 by Justice P.N. Bhagwati. Now, however, this seemingly new development, please mind the word seemingly here, we are saying that this would seem as a new development. This was not an invention, but it was a discovery. Now, since what the court had sought to do was nothing more than explore and bring light to the vital and dynamic aspect of equality that had till then been lying latent and submerged in the few simple but pregnant words of Article 40. Now, this is what we're trying to say, that arbitrariness as a facet was discovered by the case of E.P. Royappa, which existed within the article but was noticed and laid down and brought to the surface by the E.P. Royappa case. Now, a word of caution, a word of warning was given by Justice Subba Rao in the Ajay Hasya case itself, where it said that the doctrine of classification was only evolved as a subsidiary rule. So we do not intend to overrule doctrine of classification over and above the doctrine of equality. What we mean to say is that the content of the substantive portion of Article 14 talks about the doctrine of equality, but over and above that, to exercise the fundamental right, the doctrine of equality, to check the legislations on the parameters of Article 14, we have evolved a subsidiary rule, which is doctrine of classification. Now, since we have now seen how we have moved from the constitutional jurisprudence has moved from the reasonable classification test till the test of arbitrariness, we now see what are the criticisms of Rajbala versus State of Haryana. What is the problem with the newly found interpretation or definition of our doctrine of arbitrariness? Now, the very first problem that I have is the procedural problem. The judgment of Rajbala versus State of Haryana suffers from the vice of judicial indiscipline, in that as it was pronounced by a two-judge bench, overruling the judgment given by a larger bench. Larger benches being in the case of Ajay Hasya, being in the case of E.P. Royappa. There have been a number of judgments which have cited the doctrine of arbitrariness, which have upheld the doctrine of arbitrariness as an important facet of Article 14, unlike Rajbala, which has tried to ignore the ground of arbitrariness as a challenge to the constitutional validity. Now, we can see the Central Board of Dawoodi Bohra Community versus State of Maharashtra had laid down 2 points, that a law laid down by this court in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength. Now, similarly, if we had a bench which a division bench which had given the judgment in the previous judgment also, we would not have a problem with this judgment. Hence, the problem of judicial indiscipline arises. Now, the second problem I have with this judgment is the substantive due process. Now, the court's reluctance to apply arbitrariness doctrine in the case of Rajbala while reviewing the constitutionality of the statute also stemmed from the fact that it would amount to an importation of a doctrine which was a US based doctrine of substantive due process, which Indian constitutional system does not merit of, does not warrant. Now, we all know Article 21 talks about procedure established by law. Until Menka Gandhi, we knew that we have a due process of law distinguished from a procedure established by law. But with Menka Gandhi, just, fair, and reasonable test was drawn, and it was said that whenever we are checking the constitutional validity of the law, whenever we are checking the whenever we are checking the validity of a law, we are trying to understand the we are trying to have JFR test, that is just, fair, and reasonable test. Now, with this, we have included due process of law and procedure established by law do not have any difference, and they are uh, both are facets of Article 21. Now, with this development, we now intend to say that substantive due process is a part of law, and hence any hesitation to bring in an interpretation in so as to not import substantive due process would defy the whole process of bringing the constitutional jurisprudence or evolutions in in this respect. Now, the third problem that I have is that the state of Andhra Pradesh versus McDowell's and Company, the case was that the decision in McDowell was to the effect that a mere assertion of arbitrariness, which is short of due substantiation, with reference to the provisions or scheme of the Constitution will not meet the legal threshold of the arbitrariness required for invalidating inconsistent enactments. Now, with inconsistent enactments, we mean that enactments which are inconsistent with the constitutional standards. Thus, it is submitted that McDowell did not foreclose the arbitrariness challenge for good. It simply insisted on a well founded and concrete claims premised on the provisions of the Constitution or the constitutional law. So the intent of McDowell was to only say that whenever you are proving constitutional validity, you have to prove it on well-founded and concrete claims which are premised under the in the provisions of the Constitution or constitutional law itself, and simply not saying that it wants to foreclose the arbitrariness principle as a principle in its entirety from Article 14. Now, with this, if we are saying that arbitrariness is not a ground anymore post Rajbala, what is that we are looking at as a standard of judging a standard of negation of any legislation under Article 14? We are looking at resurrecting new standards for doctrine of arbitrariness in light of the rule of law. Now, there was a recent judgment of Subramaniam Swamy versus CBI, which has opened possibilities of indirect application of arbitrariness standards in constitutional adjudication concerning parliamentary enactments. Now, what we have to understand as a difference here is that we are looking at two types of legislations. One is state legislation or the ordinary legislation. The second one would be the parliamentary legislations. Now, as far as EP Royappa and other judgments have been in concern, we are talking about we are talking about the parliamentary enactments. But with the case of Rajbala, we have seen that doctrine of arbitrariness would not apply to the ordinary legislations. Now, this is where there is a difference between ordinary legislations and parliamentary enactments in the application of doctrine of arbitrariness. Now, this whole standard of arbitrariness, of doctrine of arbitrariness, we are developing or resurrecting on the doctrine of rule of law itself. We are trying to bring in the three tenets, the three principles of rule of law as given by A.V. Dicey, to say that we are indirectly applying the arbitrariness standard in the constitutional adjudication which concerns the parliamentary enactment. Now, in total, we can conclude with the foregoing analysis, which reveals that arbitrariness is in fact the one and only test applicable in an equality analysis under Article 14 for any form of state action. When it concerns the distributive aspect of state action, it implies comparative unreasonableness, and hence the reasonable classification standard gets triggered, which itself is informed by the principle of arbitrariness. In the case of non-comparative unreasonableness concerning the primary legislation, which is the parliamentary legislation, the appropriate form of analysis is not quite clear, and that brings into question the legitimacy of the whole exercise of checking of negation, or checking the validity of the statute under Article 14. Notwithstanding this cloud of legitimacy, such an exercise is undoubtedly constitutionally permissible. The checking of the action on the grounds of Article 14 is constitutionally permissible. But it is, however, advisable that the judiciary should introduce some clarity in this aspect, perhaps through authoritative pronouncement of a larger bench. Now, the possibility of adoption of reasonable standard as explained above may be mooted, or even introduction of a differential standards of review applicable to primary legislation which is short of foregrounding select list of fundamental rights, which is that we want to propose a preferred freedom system. Now, with the preferred freedom system, I want to contend that there are certain cases, there are certain legislations where we are trying to invoke certain grounds of review which would not be applicable in certain other contexts. And this is where I propose the solution should be that we should institute the concept of preferred freedoms. I hope this is clear to you all. Thank you for your attention.